Chicago's morning answer on AM 560.
Being bad feels pretty good.
The Answer.
Dan and Amy and House Judiciary Chairman Gerald Nadler was none too happy that Don McGahn pulled a William Barr and was a no-show to his committee hearing yesterday, saying this.
When this committee issues a subpoena, even to a senior presidential advisor, the witness must show up. Our subpoenas are not optional. Mr. McGahn has a legal obligation to be here for this scheduled appearance. If he does not immediately correct his mistake, this committee will have no choice but to enforce the subpoena against him.
Yeah. Doug Collins, the ranking Republican on the committee, was less compelled by Gerald Nadler's moral indignation than Nadler's caucus mates.
You know, this is becoming a pattern. The chairman knew this, I believe, when he sent the subpoena last month, but instead of inviting the witness to testify voluntarily and working with McGahn's counsel to find mutual agreeable time and scope for the testimony, the chairman rushed to maximize headlines by issuing a subpoena. That subpoena was the third in just 4 months, more subpoenas than the prior chairman issued in 6 years. The chairman had several ways out here. He took none of them. A closed-door conversation would not have generated those headlines, and everything that we're looking at today, even gaveling in today's hearing without a witness, is theatrical. The cameras love a spectacle, and the majority loves the chance to rant against the administration. I just am glad today to see that we don't have chicken on the dais.
Oh, boy, Steve Cohen shot there. For more on this topic and that theater, we're pleased to be joined again by famed Harvard law professor and author of the book, The Case Against Impeaching Trump, Alan Dershowitz. Professor, thanks for joining us. Appreciate it.
Well, thank you very much for having me on.
So what about the Nadler/House Democrat position of just endless subpoenas and litigation over Trump documentation?
Well, I have a column coming out in today's The Hill in which I argue that this reminds me of my early days as a lawyer during the time of McCarthyism, when the Congress, that time under the control of Republicans, issued subpoenas not for appropriate legislative purposes, but for strictly partisan and ideological purposes, to embarrass people who had been communists in the 1930s, to get professors and actors and others fired. And ultimately the court said enough was enough. And I think what's going on here is a misuse of congressional authority for partisan purposes. Look, Congress does have the right to have hearings in order to legislate and to engage in appropriate oversight. But I don't think anybody believes that's what's going on here. The oversight and the legislation is a pretext for simply exposing what they believe are problems within this administration to public view. And ultimately, the courts will strike that down. The district court did not. I think the district court wrote an opinion that I said could have been written by a very conservative judge back in the 1950s. But I would think that every civil libertarian should be concerned about the misuse of Congress's authority, because today it's misused against President Trump. Tomorrow it could be misused against Democrats. And the day after tomorrow, it could be misused against you and me. If you give Congress the authority to go after anybody for any purpose without really having a legitimate legislative purpose, you're really violating civil liberties.
Well, and also lost in much of the histrionics, the fact that Barr has said regarding Mueller's testifying before any House or Senate committees, it's up to him. If he wants to testify, he can testify. And in addition to that, there was a CNN report yesterday that Barr's team is trying to forge some kind of compromise with House Intel Chairman Schiff, overseeing some of the underlying documentation to support Mueller's conclusion in part one of his report that there was no collusion. So it's not like justice is not engaging or taking a posture adverse to the legitimate oversight functions you're describing. There's ample evidence that's quite the opposite.
Yeah, and, you know, both sides are playing a little bit to the crowd. I think it probably would have been better for either McGahn to have written a letter formally invoking executive privilege, or showing up at the hearing and issuing a statement saying why he could not answer any questions. I think he played a little bit into the hands of the Democrats by simply not complying with the subpoena. But again, even if he had complied with the subpoena, he wouldn't have answered any of the questions. He would have had a right not to under executive privilege. And then if they weren't satisfied with that, they could take it to court, and the court would almost surely sustain the invocation of executive privilege. So I think we see both sides trying to gain some partisan advantage here, and the big loser are the American public, and they're not seeing the legislature engage in actions which they're paid to do, that is legislate, and engage in proper oversight. Right now, the Democrats are arguing among themselves as to whether to open an impeachment inquiry. If they open an impeachment inquiry, obviously they have broader powers under the impeachment clause to subpoena and to compel testimony, but they haven't done that for their own political reasons, and I think for constitutional reasons, because I don't think there's a grounds for impeachment. But we may be moving in that direction.
No, you know, even if the House passes an impeachment resolution, we know the Republican Senate will reject it. But what I know you
the
said,
Republican Senate has no control over that.
Okay.
An impeachment resolution is only by the House of Representatives, because under the Constitution, the House has exclusive authority to impeach, and the Senate only has the authority then to try. So the House alone can impeach the president, as the Republican-controlled House impeached President Clinton back in the 1990s.
No conviction.
Or what do they think they have on him to, go forward with an impeachment resolution?
Well, you have Congresswoman Waters, who said you don't need anything. Impeachment is whatever the House decides it is. And she was actually paraphrasing former President Ford when he was majority leader of the House. He made the same unconstitutional statement. That's not true. The Constitution provides specific grounds for impeachment, to treason, bribery, or other high crimes and misdemeanors. And unless those criteria are met, impeachment would be unconstitutional.
And concurrent with this, of course, is the Department of Justice doing a look back at 2016, Barr appointing U.S. Attorney out of Connecticut, Durham, to ride point on that.
Well, I have to tell you, that vindicates what I've been saying from day one. From day one, I said there never should have been a special counsel appointed. There should have been a bipartisan, nonpartisan expert commission like 9/11 to look at the entire 2016 election and the attempt by Russia to influence the election and what can be done to prevent that from happening in the future. That would have been much better than a closed-door special counsel who operated in front of the grand jury where the material is secret, where it's ex parte, where there's no opportunity to come with a defense lawyer. It would have been so much better to have hearings, open hearings in public, where all sides of the issue could be presented. And the real villain here, which is Russia, could have been exposed to public view.
Well, and the look back, too, I know people want to focus on Hillary, but it seems to me the emphasis is on the decision-making to launch the investigation, how the investigation was pursued as well. And there are a lot of legitimate questions where you have people telling mutually exclusive stories. Jim Comey and Loretta Lynch tell a different story about instructions. Jim Comey and John Brennan have a different recollection about the Steele dossier. Jim Comey and Andy McCabe have a different story on the dossier. So the combination of the forthcoming Inspector General report from Justice, as well as this independent look back at 2016, they're legitimate questions that need to be answered, right?
Oh, I agree with that. Not only that, but one of the most important questions from a civil libertarian point of view. And remember, I'm a liberal Democrat who voted for Hillary Clinton. I'm in this game only to protect civil liberties because the ACLU has taken a pass on this and they don't defend civil liberties anymore. And one of the most important civil liberties questions is the FISA application, because FISA is a very special court. It's operating in secret. It receives ex parte communication from the government, which it expects and hopes to trust. And when the government provides less than complete information and doesn't provide ongoing corrections to the information, that's a core violation of civil liberties that can affect the rights of every American who's surveilled or subject to FISA warrants or applications.
And isn't another issue along those lines the unmasking of General Flynn?
Well, I don't know enough about that to comment, but I think that's certainly worth considering, which is why I really wanted to have a commission, which is nonpartisan, not looking to gain partisan advantage, looking at it holistically the way the 9/11 Commission very excellently looked at the whole issue and came to conclusions which the United States government, at every branch of the government, incorporated into their actions in the future. That's what should have happened after the 2016 election. But everybody wanted to see the problem to gain partisan advantage. And again, the victims of this are the American public, who don't benefit when each side tries to gain partisan advantage.
I wanted to ask you about the Equality Act. Democrats in the House celebrated Friday that they passed it. What do you think of that? It would add sexual orientation and gender identity to the federal civil rights law. How do you feel about it? And do you think personally that, it might criminalize Christianity?
No, I don't want to criminalize anything, but I'd like to see broad protections for the rights of every individual, regardless of their sexual orientation. But we can provide rights without criminalizing. I certainly don't want to criminalize Christianity or Orthodox Judaism or Islam or anyone else. We have to strike balances. And we saw that in the Supreme Court case involving the baker who refused to decorate a cake for a gay marriage. Striking that appropriate balance is very difficult. It's one of the hardest social issues we have today, whether in the context of abortion rights or the context of gay rights or transgender rights. And I would think that we could strike that balance by protecting the rights of the individuals without criminalizing those who have a different view, and perhaps having exemptions for legitimate religious views. I have my doubts sometimes, however, about how authentic the religious views are. Take, for example, the baker who won't bake for a gay couple. He certainly would bake for a divorced couple, and yet traditional Christianity, if you look at the New Testament, is much harsher about divorce than it is about gay rights. So people are selective in what parts of religion they invoke, and often religion serves as a cover for bigotry. What if somebody says, my religion says that I don't want to have to go to a restaurant and sit at the same place with African-American people or gay people? You just have to balance that against the rights of individuals, and that's what legislation is supposed to do.
I wanted to ask you, going back to Harvard Law School, about the effective termination of Ronald Sullivan for agreeing to be part of the defense team in the Harvey Weinstein case. He's a law professor at Harvard, well respected. He's also a criminal defense attorney. That's what he does, which is why he's representing or agreed to represent Weinstein. I mean, with the culture now at places like Harvard Law, you would have been kicked out for representing Klaus von Bülow.
Well, Harvard Law has been very good on this. It's Harvard College that has it. The Harvard Law School faculty has stood behind Ron Sullivan almost completely. And I think the students stand behind it. Law students have to stand.
Professor, we're losing you a little bit. I'm sorry. You're...
Okay, I'm sorry. I'm saying the Harvard Law School has stood behind Professor Sullivan for the most part. It's Harvard College, and particularly the dean of Harvard College, who basically fired him instead of using this as an educational moment to teach students the importance of why John Adams represented the people accused of the Boston Massacre and why I represented Klaus von Bülow or O.J. Simpson. Today, I think a lot of the college students don't believe in process. They don't believe in free speech. They don't believe in due process. They don't believe in fair trial. They think they know the truth. And if a person's accused, he must be guilty. If a person has a view different from theirs, it must be wrong. And I think we're going into a very dangerous area and led by colleges. That's why this was a real educational moment for Harvard University and Harvard College, and they flunked. They got a flunking grade, and the dean got a flunking grade. Instead of using this to educate students, he just gave in to the loudest screamers who claim that they felt unsafe. Unsafe is the new mantra of McCarthyism. If you feel unsafe with Ron Sullivan at your dean, what about somebody who feels unsafe with a Muslim dean or a gay dean or a Trump supporter dean or a libertarian dean? You name it. Anybody can claim to feel unsafe. And if that triggers a response like firing somebody, we're really, really onto some very dangerous times. People felt unsafe in the presence of lawyers who defended communists during the McCarthy period, which is why I think this is one of the most dangerous violations of academic freedom in the 55 years I've been associated with Harvard University.
He is former Harvard law professor, and he's also the author of the book, The Case Against Impeaching Trump. Alan Dershowitz, thanks so much for joining us. Appreciate it.
Thank you so much.
And he joined us on our turnkey.pro answer line.
The stories you need to know to start your day. This is Chicago's Morning Answer on AM 560.